Hello friends, today in this session we are going to discuss the case Hussaina Bai vs. Zohra Bai. Let us first understand this case briefly. In this case, Hussaina Bai claimed ownership of two houses illegally gifted by Johra Bai. However, the court rejected her claim. The defendant argued that she was mentally unwell and the gift deed was executed under undue influence. The High Court found that the plaintiff had not established actual ownership of the gifted property and that the transfer of property was not proven. Under Muslim law, for a gift deed to be valid, there must be voluntariness, transfer of possession, or a renunciation of ownership, which were not demonstrated in this case. Consequently, the appeal was dismissed. Now let us study this case in detail. Answer: Hussaina Bai Petitioner vs. Johra Bai Respondent. Reference AIR 1960 M.P.60. Subject matter: if a gift deed which is obtained under coercion or undue influence valid under Muslim law. Facts of the case: the petitioner asserted her rights over two houses belonging to the respondent, one located in Nagpur and the other in Burhanpur. As these properties were mentioned in the gift deed, thereby confirming their ownership, the petitioner argued that the joint consent was not necessary for the transfer of property. The central question was whether the gift deed was executed voluntarily or was obtained under coercion and whether it was valid under Muslim law. Investigation Court. The Additional District Court at Khandwa dismissed the petition and the claim for entering benefits made by the petitioner Hussaina Bai. Hussaina Bai, the petitioner, was the daughter of Asma Bai, who was the sister of respondent Johra Bai. Asma Bai was married to Noman Ali. Johra Bai, the respondent, was married to Shamsher Ali in Nagpur, a man of considerable wealth. Shamsher Ali had a daughter, Zainab Bai, from his first marriage, but he had no children with Johra Bai. Johra Bai was dear to Hussaina Bai, who had raised her. Hussaina Bai was previously married to Kedar Bai of Bombay, but they divorced in 1946. Shamsher Ali passed away in 1944. On 24 March 1944, he prepared his will in which he bequeathed most of his property to his daughter Zainab Bai and allotted two houses, one in Nagpur and one in Burhanpur, to his wife Johra Bai. In addition, Johra Bai was granted a lifetime right to enjoy the income from another house in Nagpur, provided she did not remarry or until her death. On 18 January 1947, Hussaina Bai asserted her claim over the houses on the basis of a gift deed which bore the signature of Johra Bai, the respondent. This gift deed was written in Hindi by a man named Baldev, who prepared court petitions in Burhanpur. It was attested by Saleh Bhai, who was the petitioner's uncle. Additionally, Muhammad Ali, also known as Muhammad Hussain, who was the son of the petitioner's paternal aunt, attested the deed. The gift deed was executed on Asma Bai's property and it was duly registered. Asma Bai was Hussaina Bai's mother. On 26 April 1948, the respondent Johra Bai declared the gift deed invalid by the means of a registered notice and subsequently prepared another document. Finally, on 29 May 1950, the gift deed was completely revoked. The trial court dismissed the petitioner's claim. High Court. Hussaina Bai appealed before the High Court. The High Court considered the arguments presented by the respondent and concluded that the petitioner had no right. Defendant's argument. Point 1. The defendant, who was not in good health and was mentally distressed, did not make the donation voluntarily or in a full consciousness. Rather, it was obtained through undue influence. Point 2. The gift deed was executed under undue influence exerted by the defendant's brother, aunt Sukhan Bai, and mother Asma Bai. Point 3. The property was offered as a gift by the defendant, but the plaintiff did not accept it. Point 4. Despite the alleged gift deed, the actual transfer of the property did not take place and the defendant remained in possession of the property as before. The trial court considered all points in favor of the defendant and based on this dismissed the plaintiff's suit. The High Court found no evidence of the transfer of possession of the Nagpur house, nor did any tenant acknowledge the plaintiff as the owner of the house. The High Court also noted that the defendant had registered the Burhanpur MP house in the municipal record under her name, but it appeared that this was done after a dispute between the plaintiff and the defendant in March-April 1980. The Muslim court was located on the upper floor of the Burhanpur house, which was licensed by the defendant. Relying on the principle of Muslim law outlined in Mullah's 14th edition, the High Court concluded that in cases of joint ownership, the donor must perform a clear act demonstrating the transfer of property and relinquishing control over it. On this basis, the High Court dismissed the appeal and upheld the trial court's decision. Legal principle established. Point 1. If a gift deed is obtained under coercion or undue influence, it is deemed invalid. Only a gift deed made voluntarily and freely by the donor is valid. Point 2. If the gift deed is made by the donor at the time of death, the donor may revoke the gift deed at any time prior to his or her death. Point 3. It is essential that the donor perform